All right, back on the record. A further evidentiary hearing is scheduled for April 24, 2013 at 9 a.m. And I understand this is over defendant's objections. I will still deal with the objections to Exhibit 1, but obviously to the extent that those objections deal with copies of certain records and depositions not being certified. I've already indicated I agree with Mr. Warner on that, but plaintiff's going to have an opportunity then to correct that, and of course defendants will have also an opportunity to adduce additional evidence. Let me ask this: do counsel wish to have an extension on the briefing time in light of this next hearing coming up on the 24th?
Well, I haven't seen the documents that may be offered at that time. It's hard to know, so I would say yes.
All right, Mr. Casson, that would seem to make sense to me to simply have the briefing time start on April 24th.
Yes.
Okay. So the 3 weeks will start after April 24th, and then with the additional week for rebuttal. Okay. If there's no further evidentiary matters, then Mr. Casson, you may proceed with your argument.
Your Honor, the plaintiff will submit a written argument with regard to the legal aspects of this case. I would, for the court's edification, and try to succinctly put what my client's position is. That this is an issue with regard to whether or not a road is a public road, and whether or not the bridge that is part of that public road is the responsibility of the defendants to repair. That what occurred in this case is, back during the Depression, the United States of America had the notion to create a subdivision where farmers could be placed and grow crops on the land and support themselves through the Depression. There was, what the evidence will show once it is supplemented with certified copies, is that the government had a rather grandiose plan for doing this, which caused a plat to be recorded, which set certain lands out where my client's house is currently located into certain lots and dedicated roads to the public as part of it. That subdivision was later vacated by the federal government, and the county Jefferson approved of the vacation of that plat. There was then filed with the Register of Deeds a downscaled version of this plan, whereby certain lots were laid out and the street laid out in the form of a plat. That the one of the lots upon which this subdivision was created is a house upon which my client currently has a home. The position of my client is that by filing and recording the plat and dedicating the streets to the public, that at the time, the law that existed at that time, was a conveyance by the federal government, fee simple, of the lands dedicated as streets to the public. That the government thereby retained no interest in them. It would be as any other subdivision, that these areas became public areas, which in this case included only a street and a road and a bridge. That the owners of the property thereafter petitioned the county board to assume maintenance of the road and bridge dedicated to the public. The record would indicate that the county board declined in the 40s to accept maintenance of that road and bridge. What my client's position is that in years thereafter, the county assumed responsibility for the road and the bridge by actually maintaining the same and by repairing the bridge, thereby the public road became their obligation to maintain as a matter of law. That what we have today is that the county board, Jefferson County, refuses to acknowledge that the road is a public road for which they have an obligation to maintain, and that the bridge over a creek, which is part of the road, that road system, is not their responsibility, and refuse to repair the bridge so that my client can have public access, the only public access to his property. That is, in essence, the thrust of the lawsuit, and what we're asking the court to do is to order that the county recognize that this road is a public road, that the county has a duty to maintain not only the road and the bridge. That there is a tricky issue with regard to the maintenance of the bridge or reconstruction of the bridge, and that would be addressed in legal brief that would be submitted, because there is some question as to whether or not the court can order, if it so finds that it's a public road and public bridge, that the county is required to repair or replace that bridge. But that would be addressed in the written argument. Thank you, Mayor.
Thank you. Mr. Warner?
Well, Your Honor, in some things we do agree. There is no question that the United States of America, acting through the U.S. Department of Agriculture and the Farm Security Administration, platted this land. The affidavit of Kristen Timmerman clearly shows that the United States of America owned the real estate. They sold off various lots, it's true, including one to Michael Diller, as he indicates, predecessor in title. And when they did plat this, it was a part of the New Deal by Franklin Delano Roosevelt. And we don't disagree about that. The Farm Security Administration spent billions of dollars building roads and building bridges. And they built tens and tens of thousands of bridges throughout the country. It's a matter of history. But there was no conveyance to the county of the road. Does the county have to accept the road owned by the United States of America? I submit to the court that it does not, and it did not. Prior to there being a petition before the Board of County Commissioners, attached actually to plaintiff's exhibit and not objected to, is a conveyance from the United States of America to Lester and Vera Felton, which is the same description as to the real estate that Mr. Diller, the plaintiff, owns. It says, it is subject, however, to such easements and rights of way across and through and above the described lands as hereto have been granted by the United States of America or its predecessors in title for the construction, operation, and maintenance of public utilities, streets, roads, and walks, and also reserving an indication that they reserved that right in the United States of America that I just read. They reserved the right in the road. And then, knowing that they had the ownership of the road, because the affidavit of Kristen Timmerman, the registered abstractor, shows that there were no conveyances of this road. The United States, she lists the documents that affect the road and finds that her research showed no other documents other than the petition that Mr. Casson referred to.
And this is one of the exhibits I have.
That would be Exhibit 6, numbered Exhibit 6 of Exhibit 1, plaintiff's affidavit. Is that deed.
And that you're not objecting to?
I did not. But holding title at that time in 1945 there was a petition of the United States of America to the county board to dedicate it. And it was signed by the United States of America. We don't have the actual petition, but we do have the wording of the county board minutes, which shows that the United States of America and other owners at that time wanted to dedicate it to the county. And the county in 1945 held that open for a month. And after a month, they reconvened in June of that year, 1945. And the record indicates that it was moved and seconded to reject the petition referred to. And it passed. And that was the end of the public record with regard to this road. Now, counsel for Mr. Diller asserted that by adverse use or prescriptive use, there was somehow a dedication of this land to the public that resulted in the county becoming responsible. But that is not so, because there are some cases in Nebraska where that did happen. But the difference is that this is the United States of America. This is the big political subdivision that had the power to tax and built the road, built the bridge, and has the power to continue to maintain it by raising money to do so. And there are cases in Nebraska which say that the county board is not obligated to take over a road that's owned by another political subdivision. And I will cite those cases to the court in my written brief. But also, there can be, and by statute in Nebraska, there can not be, and by court decisions, there cannot be any prescriptive rights obtained against the United States of America or other political subdivisions. And so even if the county did maintain as good Samaritans this bridge in some fashion, although if you look at the affidavit of Larry Lewis, who is a civil engineer, it was not maintained because it is in very bad shape. And that the court has. But if there was an occasional maintenance, it makes no difference because the county cannot obtain title to that road or responsibility to that road unless it is conveyed from the federal government. And
is there any evidence in the record that I have so far that indicates there was occasional maintenance by the county?
Well, it depends on, there may have been, but I will tell the court that if that record comes in over my objection, and I will have to renew my objection made during the deposition, but if that comes in, it still does not change the law or the situation. And the county has to accept any conveyance. And there is absolutely no proof. And the affidavit of Kristen Timmerman indicates there are no other documents it found during her search. And I submit to the court there will not be any other documents found that indicate that there was a conveyance or a petition like the one that was rejected to the county commissioners who took affirmative action to say, we will accept it. And that's what's required where you have another political subdivision. This is a mandamus action, and mandamus court knows, is a very extraordinary remedy, and it's not a remedy of light. The burden of proof is always on the plaintiff to show that the county board's decisions are not discretionary, but are ministerial. The object is not for the court to legislate and say what the commissioner should do. It's got to be what they have to do. And I submit that under the facts of this case, it's not there. If there is some judicial action, mandamus is one that will not be used. It must be absolute. There are all kinds of case laws on it, and not all cases. For instance, there was one out of Gage County that went to the Supreme Court, and Judge Rice refused to order the county to maintain. And it was upheld. And the court will have that brief. And it is significant that the county commissioners found that there are some 200 bridges in this county, and 92 of them, almost half, are deficient and in need of repair.
Was that Gage County case involving federal land like this?
I don't recall at this point.
Okay, but you're going to
I
send
will
it to
find it. But the affidavit, Bill Hansel, with the certified copy of the commissioners, refers to the need of the public in the maintenance of other bridges. And these other bridges are more important for the public good. I assume that, and from one of our photos, the court can see that this is not on a mail route, it's not on a bus route. It is a situation where it is largely farmland with 2 homes, and this is more akin to a driveway than a public road, because the public, other than going to these houses, has no need or opportunity to use this road because it goes nowhere else. And so the commissioners have to balance the need of the public to maintain other bridges and other roads, and the inability to do all plus this. And they passed a resolution, and that resolution is before the court. And I submit to the court that shows the discretionary nature, the judicial nature of the decision of the county commissioners as to how to spend public funds. It is not for the court to tell them how to spend the public funds, particularly on a road that is not owned by them. And there is case law in Nebraska, and I will cite it, that says the county should not expend funds on roads that are not owned by the county. And so, ultimately, I think the record will be clear that this is not the county obligation, because it's not the county's road. It's the United States of America. And therefore, the county has no obligation. And even if it was considered a county road, the extraordinary writ of mandamus does not apply, because they have a judicial function, and that judicial function solely to them. And I might say that resolution was not appealed under the Procedures Act. So it is valid if it's a judicial function. And therefore is